Hello, fellow classmates. For today's Civil Liberty Project, my group and I decided that we were going to focus on the topic of racial discrimination regarding segregation and voting rights.
Hello, my name is Brandon Beneski. Today I'll be talking about some of the most important U.S. Supreme Court cases in regards to segregation in America. The first one I'm going to be talking about is Plessy versus Ferguson. This case was to challenge a Louisiana law called the Separate Car Act. This act made all Louisiana car companies must have two separate car compartments, one for white passengers and one for non-white passengers. The problem with this law is that it was separate but not equal, as the white cars were in far greater condition than the non-white cars. And a group of civil rights activists kind of teamed up and decided to try to figure out a way to fight this law, as for the penalty for sitting in the wrong car compartment was a fine of $25 or 20 days in jail. So what their plan was to have, they chose Homer Plessy, as he was a 1/8 black male, to buy a first-class ticket for the white car compartment. When he went to sit in the car, he was actually quickly apprehended and arrested. He brought this to the local state courts, as it violated his 13th and 14th Amendment under the U.S. Constitution. After losing twice in the local state courts, he appealed it to the U.S. Supreme Court, where actually Justice Henry Billings Brown decided to appeal the previous decisions that racial segregation is constitutional under the separate but equal doctrine. This is a quote that he said during that day. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law. From the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social, as distinguished from political, equality, or a commingling of the two races upon terms unsatisfactory to either. To kind of simplify this a little bit more, he believed that the 14th Amendment kind of protected you as a citizen in the U.S. as far as how the law treats you and how the law sees you, but not in the the condition of the separate cars, and just the kind of more like social equality that kind of happened with racism in America. He didn't feel that the 14th Amendment was supposed to protect you from that. But even though this case did fail, it did set up for the next big case I'm about to be talking about, the Brown versus Board of Education. So the U.S. Supreme Court case, Brown versus Board of Education, is about Linda Brown and her little sister, two black elementary school students, who on their way to school, they had to cross a dangerous road crossing to get to a bus, which then drove them all the way to their non-white school that they had to go to. While even closer, there was a school designated for all white students where they didn't have to make that that dangerous trip. Her mom was obviously upset about this, as it violated her 14th Amendment. Because of this, Linda Brown's mom decided to take it to the federal court, but the federal court decided that because the black and white schools have similar buildings, similar transportation, curriculum, and teachers, that it's a legal form of segregation under the separate but equal policy. The Browns then appealed this to the U.S. Supreme Court, where they stated, even though the facilities were similar, there's no form of segregation that can be equal. Chief Justice Earl Warren agreed with them and said, "We conclude that the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." The court then decided that the state law requiring separate but equal schools violated the Equal Protection Clause of the 14th Amendment, and has then desegregated schools in Topeka, Kansas.
The group and I decided to choose the topic racial discrimination, and I will be starting off the presentation. Constitutional provision. There are many examples of constitutional provisions, such as the first 10 amendments to the U.S. Constitution, freedom of speech, and freedom to vote, just to mention a few. These are important because they guarantee certain civil rights and freedom. The 14th Amendment. The 14th Amendment was ratified in 1868, and it provided equal protection of the laws, mainly for African American people. But soon after the 14th Amendment, people from the South started to prohibit the blacks from attending the same schools as white people, or even hospitals and other facilities. The Supreme Court ruled that separate facilities were illegal as long as everything in them were equal to each other. In 1954, in the Brown versus Board of Education case, it was decided that it was unequal to have separate educational facilities and that it violated the laws of the 14th Amendment. Little Rock High School. Most Southern whites did not agree with sharing facilities with African Americans. A historic riot occurred in 1957 where the National Guard did not let the black students enter Little Rock High School in Arkansas. I will play a few seconds of this video.
What about you, sir? Do you think the college students will show up? If I got anything to do with it, they won't show up. Well, I think it's a breaking point of the school integration. I just don't feel that they have a right to go to school.
It is easy to believe today that we are an enlightened society, free from problems of race, gender, or economic separation. But some of the most difficult lessons we learn are a result of individuals who push us through these divisive barriers.
Even though the Brown decision ended segregation in public schools, many African Americans continued to stay together and attend schools where most of the students were black. The 15th Amendment. The 15th Amendment prevents the government from denying a citizen of the United States the right to vote based on the color of their skin. Even after the 15th Amendment, Southern whites created rules against the blacks like white-only voting polls so that African Americans did not get a chance to vote just like everyone else. The Supreme Court eventually decided that whites-only elections were unconstitutional.
My name is Juan Zavala Sandoval, and I will be going over relevant legislation and executive orders regarding racial discrimination. It is important to understand what is meant when using the word legislation. According to yourdictionary.com, legislation is defined as laws and rules made by the government. The legislation that we will be exploring today are laws made by the government regarding racial discrimination. Now that we have an understanding of what is meant by the use of the word legislation during this project, we can now turn our attention to Title VII of the Civil Rights Act of 1964. According to the website aauw.org, Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. It is important to remember that this act generally applies to employers with 15 or more employees and includes federal, state, and local governments. Title VII also extends itself to private and public colleges and universities, employment agencies, and labor organizations. You may be asking yourself, though, how does Title VII do its job? One of the ways that Title VII does its job is to forbid discrimination when it comes to employment. Some examples of this include the hiring and firing process, recruitment, and the use of company facilities. It is important for the listener to know that this title does cover way more categories than what was provided in my examples. Any person who feels that they were discriminated based on any of the examples provided are allowed to assert their rights under this act. They do not need to feel like they will be faced with consequences of their action because this title does protect them from retaliation. The final piece of information that I will be leaving the listeners with is executive orders regarding racial discrimination. Something very interesting happened on December 11th, 2019. Our current president, Donald Trump, signed an executive order on combating anti-Semitism. According to whitehouse.gov, President Trump signed the executive order which gave federal agencies permission to use Title VII. This order specifically prohibited federally funded governments from discriminating based on anti-Semitism. This order was created so that the government can combat anti-Semitism. President Trump's interpretation of Title VII and the signing of the executive order had its critics. Some of these critics argued that Jews are not a race or nationality, but this is something that has been argued way before Trump signed this order. In 1964, Senator Joseph Clark of Pennsylvania suggested that Title VII should include banning anti-Semitism in federally funded programs. Mr. Clark's view was not shared by the other senators, which is why it did not go through. This was not brought up again until 1982, when a synagogue was spray-painted with swastikas in Silver Spring, Maryland. The synagogue and its members sued the vandalizers of their place of worship. During the case, the plaintiffs argued that even though Jews themselves were not a race, the vandals viewed Jews as a race and were motivated by racial hate. The case reached the Supreme Court, and the verdict led to victory for the synagogue. While President Trump is not the first person to have that same interpretation, he is the first person to implement it as an administration-wide policy. From all of us in this group, thank you for viewing our presentation. We really appreciate it.